I've heard that I may be an heir to a California intestate estate. What does that mean, and how does it benefit me? Hello again, this is Certified Probate Real Estate Specialist Daryl Williams with Win-Win Realtors here in Southern California. If you are new here and you like our content, be sure to like, share, and subscribe. Let's get started. An heir is an individual who is entitled by law to receive assets of a person who passed away without leaving a last will and testament. Many people believe that heirs and beneficiaries are the same. However, they are not. A beneficiary was named in a will by a deceased person, whereas an heir is entitled to receive assets from someone who died without a will. Dying without a will is called dying intestate. The following example should help you understand this concept. Your close friend or non-relative can receive assets from your estate if you name that person in your will. However, if you were to die intestate, meaning without a will, your close friend or non-relative would not be entitled to any assets from your estate. Here are the different types of heirs, and this should help you identify if you are a possible heir and where you fit in. Heirs-at-law. An example of heirs-at-law would be a surviving spouse or children of the decedent. California intestate succession laws establishes the order based closely on the relationship or direct relationship with the deceased person. The grandchildren would not be direct heirs unless their parents had passed away. Let's take a look at another type of heir. Collateral heirs. An example of collateral heirs would be the deceased person's parents, siblings, or grandparents, and the next of kin of the direct heirs-in-law. These persons are known as collateral heirs because they can only inherit property if there aren't any direct heirs-in-law still living. Let's take a look at the last type of heir. Unknown heirs. When a person dies and have no heirs-in-law, the state of California requires a special notice to be placed in the newspaper so those who believe they are related to the deceased person can be recognized. The court will conduct a process to determine heirship. If heirship is determined, that person will be allowed to inherit. If heirship is not determined, the deceased person's property will go to the state via something called escheat. Have you ever discovered that you were an unknown heir in a probate estate? If so, tell us about that experience in the comments below. If you haven't done any estate planning at all, you may want to consider preparing a last will and testament. That way, if you have close friends, you could make sure that they are entitled to part of your estate if that's what you would like to happen. I'm Daryl Williams. This is Win-Win Realtors TV. If you have any questions for me, my contact information is in the description. This video has been for information purposes only. It is not legal advice. I am not an attorney. If you need legal advice, please contact an attorney. If you need an estate planning or a probate attorney here in the Southern California area, feel free to contact me for a referral.